Hi, Kyle Osgood here. Welcome back to the weekly wrap-up brought to you by Tech Law Decoded, where I give you weekly updates on the latest on tech and antitrust. This week, I'm going to devote the whole episode to a major development in the US, which involves two lawsuits being filed by government agencies against Facebook. As a reminder, this is not legal advice, and the views expressed here are my own. So let's talk about the antitrust complaints against Facebook. They are brought by two different authorities, you could say. The first is the Federal Trade Commission, which is one of the two main federal antitrust agencies in the US that's responsible for enforcing the antitrust laws. And the other complaint is brought by a large group of 48 states, which are also alleging violations of federal antitrust laws against Facebook. So what is similar about these complaints and what is different? Let's start with what's similar. What's similar about the complaints is that they both allege a so-called monopolization claim. And a monopolization claim involves allegations that a company has a large amount of market power and that it's using that market power in a way that excludes competition. Here, the complaints allege that Facebook has monopoly power in a market for personal social networking, a market where the complaints allege at least a 60% market share and possibly higher, as well as high barriers to entry that make it difficult for competitors to form competing social networks due to the difficulties of attracting users and other market conditions that make the position that Facebook has durable over time. As for how it has gone about abusing that market power, well, the complaints allege that Facebook has essentially taken what the state's complaint phrases as open first, closed later approach. And this approach reflects the fact that in the late 2000s, Facebook had opened up its platform to third-party developers. Those would be developers of apps that run on Facebook's platform or developers of websites. And the open era for Facebook and its platform involved granting these third-party developers access to key data and key parts of the Facebook system that they needed in order to make their programs and services work. This is called interoperability in the antitrust world, and it essentially just means that Facebook allowed its platform and its systems to be accessible by third parties who were developing their own products that were either running alongside Facebook or built right on top of it, for example, an app that you would use on Facebook. And the big change that the complaints allege happens in the early 2010s when Facebook starts to close this interconnectivity or block off the interoperability to certain third parties who it perceives as being a competitive threat. And what the complaints mean by that is that certain third-party app developers or website or online service providers were offering functionalities and products that Facebook perceived as being something that those companies could have then grown into a larger, more sweeping, competing social media, social networking platform. And so the allegation is that Facebook would be rather choosy in terms of who it would grant interoperability to, depending on whether the third party posed a competitive threat or not. And so by doing this, by closing off interoperability to certain third parties, this excluded competition and prevented rival social networking platforms from emerging. Now, as in many antitrust cases, the government has to prove not only that there was monopoly power and abuse of that power, but also it has to prove that there was actual harm to competition. It can't just leave it on the expectation that competition might have been harmed based on certain conduct. It has to prove that there actually was that kind of harm. And here, it's important to just keep in mind that the prevailing standard used for measuring harm to competition, which is what in the antitrust world we call the consumer welfare standard, focuses on an idea of economic efficiency that essentially boils down the analysis to whether consumers are happy and whether they're paying low prices, whether there's a lot of options for them. But of course, the issue that the complaints run into in this case are mainly that Facebook offers its products for free. So price increases to Facebook users is not a viable way to try to prove harm to competition. So what these two complaints do instead is they rest on theories of harm to competition of what are called non-price effects. And here, those take the form of like allegations of loss of innovation, choice, and quality for Facebook users when Facebook faced less competitive pressure and therefore faced less competitive pressure to improve its products and to be sort of on the cutting edge of offering the latest and greatest that users might want. The complaints also allege some price effects as well, but the price effects have to do not with consumers. Again, consumers like you and I, when we use Facebook, we don't pay a price. But there is a theory alleged in the complaint of harm to the prices that advertisers pay in terms of the advertising that they might pay for on Facebook, like, for example, when you might use an app. So this harm does involve price effects, but it involves not consumers, but advertisers. So again, it doesn't fit neatly into sort of the traditional bread and butter version of the consumer welfare standard that is used as the basis for proving harm to competition. And so in the end, these complaints are clearly sort of on the cutting edge of antitrust enforcement in tech, especially consumer tech, where products are free, where products are popular. And so the theories of harm to competition have to look beyond just consumers and perhaps also beyond just prices. Lastly, what else do these complaints of the FTC and the states have in common? Well, the remedies that they seek are one thing. In particular, both complaints would seek remedies that order Facebook to basically open itself up to third parties and to be interoperable in full. The other remedy that is sought in both complaints is a divestiture or a breakup of Facebook. It's not quite evident how that remedy that's sought fits into the monopolization claim. It does fit into another claim that we'll talk about in a moment, but it doesn't fit so neatly into monopolization claim, whereas the forced interoperability does sort of more clearly link the remedy to the theory of the case, which is the lack of interoperability against certain third parties. But again, as I just mentioned, there is another claim, and that claim brings us to the main difference between the FTC complaint and the state's complaint. And that is that the state's complaint alleges a sort of merger look-back allegation. And what I mean by that is that the states allege that prior acquisitions that Facebook made were anti-competitive and that they harmed competition. And that now a court should impose remedies to cure that harm to competition by those previous acquisitions. In particular, those allegations are surrounding two acquisitions of Facebook. That's WhatsApp and Instagram. And these sorts of allegations of consummated or completed mergers are not terribly common, but they are increasingly common in the antitrust space. And they do pose some unique challenges for the plaintiff in such a case. For example, they have to prove that the acquisitions eliminated competition and that without those acquisitions, competition would have been better off. And so that's what the state's complaint tries to allege. And it also tries to tie the merger look-back claim to the monopolization claim we just talked about by describing or alleging a sort of, quote, buy or bury strategy. Which the complaint describes as a strategy by which Facebook would threaten or drop access to the APIs that form the basis for interoperability, and do so in order to convince a company to sell itself to Facebook rather than face sort of the perils of competing without access to the Facebook platform. Now, the FTC also spends quite a bit of time in its complaint talking about this sort of same dynamic. However, the FTC does not actually allege a violation of the antitrust laws under a sort of merger look at a previous deal. It doesn't try to allege a sort of consummated merger allegation, but it does bring this into part of the narrative to support its monopolization claim. And why does the FTC not bring that sort of merger look-back claim? Well, the main reason is probably a concern about the litigation risk of doing so. And that risk arises from the fact that the FTC actually, as the one of the two antitrust agencies in the US, was responsible for reviewing Facebook's acquisitions of WhatsApp and Instagram, and it decided not to take action in those investigations. And in fact, Facebook has argued in public, in media and in its blog posts, and it also will surely argue in this case that it's the same evidence that the states are now turning to, which the FTC had access to and used as the basis for deciding not to take action against those acquisitions. And so this, is not something that legally prevents the states from seeking to unwind those deals or to find those previous deals in violation of the antitrust laws. But nor would it be for the FTC. But it surely makes it a little more difficult to make that argument in front of a court for the FTC, given that the FTC itself had reviewed those deals, whereas the states would not have had this sort of obligatory notification made to them that would cause them to necessarily have looked at the deal. So that's the sort of key aspects or the key claims in the complaints. Those are the main differences, the main similarities. What are the prospects for success that the FTC and the states have? Well, my personal take is that it's quite an uphill battle that they face on the monopolization claim. The law on sort of exclusionary monopolistic conduct is quite tough for plaintiffs in the US. The remedy sought and sort of the basis for the monopolization claim is this notion of lack of interoperability, and therefore a request for requiring such interoperability. That sounds a lot like what antitrusters call a duty to deal that you might be trying to impose on a company. And based on recent Supreme Court precedent and actually decades of Supreme Court precedent, those are very difficult antitrust claims to bring. It doesn't make them impossible, but it does make it a difficult claim for the states and the FTC to try to prove in court and win on. The states, do have a broader complaint because they do allege that merger look-back claim. However, that's not an easy claim to bring, as I already mentioned. The whole point of the merger review process that the FTC goes through is to give companies clarity about whether a deal is lawful or not. And although its decision is not a clearance of the deal, its decision not to block a deal surely is meant to provide businesses with some certainty that they won't be facing a lawsuit over that merger many, many years later. So although it's a legally valid claim, it's still going to be something that might be difficult to convince a judge, for example, given the history of the FTC's review and inaction in the previous Instagram and WhatsApp transactions. Now, what else can we say about the prospects of success in these complaints? I think the fact that both are trying to sort of push the envelope in terms of the consumer welfare standard that is used to prove harm to competition are again going to pose challenges. The reason for that is we now have 30, 40 years of Supreme Court and Circuit Court precedent that defines the consumer welfare standard quite narrowly. It focuses on, as I mentioned, economic efficiency and price and output for consumers. And so to the extent that these complaints are trying to expand out that notion, it doesn't make it impossible. It doesn't make it even economically unsound, but it certainly means that it's going to be a difficult sell as these cases get appealed to the appellate courts and ultimately, very likely, the Supreme Court. And finally, I think the other challenge that these complaints face is putting aside how to measure the harm to competition. That would be the consumer welfare standard I was just talking about. There's still the fact of having to prove such harm. And when you normally have a case involving price effects, the prices go up, the prices go down, you can imagine that is a little bit more of a clear-cut way. It's still a very difficult thing and a very challenging thing to try to prove harm to competition based on price effects. You can imagine it's going to be even more difficult potentially with non-price effects, with concepts like innovation, choice. The court is going to have to, first of all, be convinced that the plaintiffs have shown that there was harm to competition in the form of consumer choice and consumer and innovation for consumers. But it also is going to have to balance those harms against any benefits that Facebook argues also came about as a result of the conduct at issue, or, for example, the acquisitions of Instagram and WhatsApp. And surely a big focus of Facebook's case will be to say that its products were made better, it was able to innovate more as a result of this conduct. And so a court having to weigh those two sides, those sort of harms and benefits, is going to have a tough time. And this is sort of an inherent challenge of antitrust cases in general, that courts have to engage in this sort of balancing act, which will be made only more difficult by the fact that these are sort of non-traditional sorts of harms to competition that are being alleged. As far as remedies are concerned, what are the prospects for a remedy if the cases were successful on some of their claims? Well, divestiture as a remedy or a breakup of the company is a difficult one to achieve under the existing law. There is, in particular, with respect to previous mergers, there's always a concern about the difficulty of trying to unscramble the eggs. Facebook has done a lot. It claims to have integrated, for example, Instagram and WhatsApp into its business and into its Facebook platform. And so forcing a breakup of the company could make it so that the benefits or the innovation or the other benefits that might have come about from integrating Facebook like that would be undone. Now, interestingly, on the interoperability point, that's a remedy. The forced interoperability seems like a remedy that might be more achievable for the plaintiffs here. However, one wonders whether that's kind of mooted by the fact that Facebook has already, since approximately 2018, has opened up its platform again and has stopped most of the conduct, if not all of the conduct that's being alleged by the plaintiffs in this case. Now, the FTC in the states are going to say, well, we still want a commitment or an order from a court that says that they can't go back to closing off the system. Sure, that's their right to do that, and maybe they can get that in court. But it does sort of beg the question of if Facebook is already, if the market's already sort of taken Facebook there, is that a remedy that is really necessary? So, the courts are going to have a really tough time if they feel like there's been a violation of the antitrust laws here, if they feel like there was harm to competition. Even if the plaintiffs get over those hurdles, the court's going to have a tough time figuring out, well, what to do about that, how to remedy that in a way that restores competition. Does breaking up the company do that? Does forcing interoperability do that? Will some other remedies be proposed in the process? Those are really big, tough questions that will have to be answered as the case progresses. But in the end, even if the agencies and the state attorneys general were to lose the case, whether it's failed to prove a violation of the law, whether it's to fail to get an adequate remedy, there still might be reasons why the agencies would have wanted to bring this case and why they might benefit from it. First of all, there's sort of a symbolic benefit that could be gained from it. I mean, this can be sort of felt as a public flogging of sorts of Facebook. It's faced a lot of scrutiny, and I think lawmakers and enforcers are looking to show the public that they're trying to do something about those concerns that that are being voiced. And so these cases sort of provide an avenue for doing that. There's also the potential for these cases to be a deterrent effect, the mere filing of the complaints and what will be drawn out and high-risk litigations for Facebook. These are things that other companies in tech will take note of and it might influence their decisions of how to conduct their business going forward. And lastly, you can imagine these complaints also being a sort of catalyst for antitrust and other legal reforms. We've been seeing a lot of talk lately, for example, in the recent antitrust tech report that was put out by the House of Representatives. We've seen discussions in Europe about putting in place platform and online tech-specific regulations. All these sorts of discussions about reforming the antitrust laws or putting in place sort of tech regulations, these all might be things that are more likely to come about if the FTC and the state's attorneys generals struggle to put together individual antitrust enforcement actions against companies like Facebook in these cases. So in the end, really exciting developments in the U.S. The U.S. is clearly trying to play catch up to Europe, for example, in bringing individual enforcement actions against tech. And it does signal sort of a tougher stance in the U.S. than we've seen until now against big tech, as people call it. And also, it's really important to keep aware of the fact that the states are not to be forgotten. The states are active government enforcers of antitrust laws and of federal antitrust laws, and where the federal agencies might be uninterested or due to their history unable to bring a strong claim, the states might be willing and able to step up and bring it themselves. So that's it for this week. It was all about Facebook, but I think an interesting case to talk about. Have a great weekend. And as always, if you want to see more and on the latest in tech and antitrust, you can follow me on techlawdecoded.com or on Twitter @KaiRozga. Otherwise, tune in to the next video. Take care. Bye.